What's up, everybody? Welcome back. I have not had a ton of time to let this sink in and digest, but my first thought when reading this order by the judge and the affidavit by our latest or maybe repeat juror is that this is not good. This is a problem for many reasons. In this case, in the future trial for this case, and other cases in this jurisdiction and around the country, this is not what we want. This is what we have to guard against. This is what hopefully streaming trials and talking about trials publicly will guard against and not push more of. And that should be our goal. We're going to read the affidavit. We're going to read the judge's order. I'm going to answer your questions, and we're going to dig into this together and deal with it like we always do, like family, right? So let's get to it. So I first saw the order before I saw the affidavit. And of course, my first thought is I really need to see this affidavit. We need to see what this juror said. Did they agree with the 12-0 not guilty count was my first question. I did not know what all I was going to read when we got there. But of course, we will get there. First, we have findings and order on Juror Doe's emergency motion to extend the July 8th, 2024 impoundment order, which just by the way, so happened to end today, July 18th. It was a 10-day order, but now it is going to be pushed forward indefinitely. This matter came before the court on an emergency motion of Juror Doe. In case you don't know, that's not the actual name. Jane Doe, John Doe is what they say for like missing persons, or if you don't know who somebody is, or just to hide the identity. She could have called them Juror E or Juror 1, but they call them Juror Doe. To extend the July 8th impoundment order entered by this court upon review of the motion and supporting documents, including the affidavit of Juror Doe, the court makes the following findings and order. This case has garnered significant and divisive attention in Massachusetts and across the nation. Couldn't agree more. Number two, individuals associated with the case have been charged with intimidation, which charges remain pending. I also agree, but I think it's very interesting how heavy we are putting our decision-making and feeling and decisions and orders on this case on charges, not conviction, but charges, right? Not the game, but practice. Because we know charges don't always mean convictions, and that's important. Juror Doe has submitted a detailed affidavit, which I find to be credible. Juror Doe is in reasonable fear for their safety and the safety of their family if the list of jurors is made available to the public. So same thing with charges. It's like we can't treat anybody charged with the ultimate crime. I'm trying to think about how to say this without the buzzwords. If we treat them that way, then we are not presuming them innocent in the ultimate trial, like Karen Reed. If everybody just treats her as a killer, well, that's not legally appropriate either. So it goes across all charges criminally across the nation. And we always talk about that. We always talk about the presumption of innocence. It's a real thing. It's not a figment of our imagination. It's not just a nice thing we talk about in stories. It has to be a real thing that we care about. Juror Doe is in reasonable fear of their safety if they're made public. Okay. Through their affidavit, Juror Doe established that publication of the list identifying the names of impaneled jurors will present a real and present risk of personal harm to jurors and to the integrity of their service. Page 2. Through their affidavit, Juror Doe has established that there is a continuing risk of immediate and irreparable injury should the jury list be made available to the public at this time. Through their affidavit, Juror Doe has established good cause to extend the impoundment order dated July 8th until and unless otherwise ordered by this court. The order shall not preclude any juror from identifying himself or herself and or speaking to the public about his or her jury service. And I can throw in there, or prohibit the jurors from speaking to attorneys on either side or the judge if they are so inclined. If they choose to do so themselves, nothing about this order precludes them or stops them from doing that. And that's important to mention. So after reading that, I was obviously incredibly interested to hear what did this affidavit say. So let's pull that up. All right. And if you can't read it because it's not very clear because I'm reading it from Twitter, don't worry, I will read every word. All right. Since being, whoops, that's not page 1. All right, here's page 1. Affidavit of Juror Doe. Now comes Juror Doe, a pseudonym who on oath deposes and says as follows. I am of legal age and have personal knowledge of the facts set forth herein. I was a member of the jury that was seated in the recently concluded trial in the above captioned case. I just retained counsel to represent me. Again, that sucks that jurors are having to hire lawyers to do this stuff for them because of everything they're going through after a trial. It's not how it's supposed to be. That's not how we're supposed to be as a society and how we treat jurors and make them feel this way. Sometimes it is necessary, though, of course. I'm never going to tell somebody not to hire a lawyer when they feel like they need one. I think you absolutely should. I have read the impoundment order entered by the Superior Court Associate Justice Beverly Canone, which found that good cause exists to impound the list identifying the names of the impaneled jurors in this trial of the case. As I read the court's order, it is scheduled to expire July 8th unless it is extended by the court. I submit this affidavit in support of my request to extend the impoundment order entered on July 8th. So this juror is specifically asking this court to extend this impoundment, to keep their names sealed, to not allow the public to have access to their names. So this is not something Judge Bev is doing. This is not something she's pushing or doing on her own. This is specifically something this juror is asking for. I am asking that the impoundment order be extended indefinitely because I am in fear of my personal safety and the personal safety of my family if the names of the jury are made public. Honestly, if it would have just stopped there, this judge and any judge grants this motion and impounds the names indefinitely. If any juror feels this way, that is enough for an order like this to go through. Paragraph 8. I have read the impoundment order and noted on the very first page that individuals associated with this case have been charged criminally with intimidation. I am frightened for my personal safety as a result of learning that someone associated with this case has been criminally charged with intimidation. So I got to be honest with you. I have a couple problems with this one. Okay. My problem number one is this juror saying that the first time she learned, or he learned, whatever the juror is, I don't know, they learned about the witness intimidation is because Judge Bev put it in the impoundment order prior. So this information is getting out to the jurors based on Judge Bev putting charges of witness intimidation. Secondarily, I would hope at this point, if this juror has just sat through this trial where the presumption of innocence and arguments and how trials work and how the criminal procedure works in the courtroom, I would hope they know the difference between criminally charged and convicted. And I would hope as we read the rest of their affidavit here that they would see there's a lot of division and divisiveness and nasty words going back and forth on both sides of this trial. And I will just tell you, I can confirm that with 100% certainty, with firsthand experience, that this stuff comes out like poisonous venom from both sides. It really does. Not everybody on both sides, of course, not everybody, but it's absolutely coming from both sides. And so witness intimidation charges on one side and people saying that charges are being trumped up on the other side. And that's basically how this entire case has gone. To a level that, in my opinion, is unmatched in any other case that I have covered or seen. So paragraph 9, I also recall testimony from at least one witness who described being harassed by individuals and her family being harassed because of their involvement in this case. I do not know any of the specifics on any such harassment, but I fear that my family and I will not only be harassed if the names of the jurors are made public, but that our personal safety will be seriously compromised. Paragraph 9 is exactly what I was afraid of. Exactly what I said after this trial ended and after we started talking about maybe we'll get the jurors back in to talk. Are they going to read up on stuff? Are they going to hear about the pressure from each side on what they believe they should do and what they would think and feel about a juror if they didn't agree with them? Right? I was afraid of a juror reading this stuff and then going into their shell and being like, holy crap, I want nothing to do with this. I don't want to talk about what my verdict was. I don't want to talk about anything I said or did in that room. I want to just disappear and not be associated with this case at all. And I was afraid once a juror started to read through this stuff and see this stuff, that was going to be problematic. But additionally, from paragraph 9, she remembers a witness or multiple witness talking about being harassed. And this, folks, right here is one of the major problems I had with that coming in. This is not relevant at all to prove or disprove any material fact in the case. Is it happening? Are the allegations happening? Yes. Those allegations are happening. So I'm not saying anybody was lying about witness intimidation. I think witness intimidation is wrong. I don't think any witnesses should be intimidated. I don't think any jurors obviously should be intimidated or pressured to do anything other than what they think is right and true and correct based on the evidence they review. But when you allow a witness to testify to the harassment in front of a jury, what do you think that is going to do as a judge? And we said it at the time. Now the jury, and I said it could backfire on the Commonwealth, saying like, ooh, if these witnesses are all being pressured, do we really want that public pressure? Do we really want people coming after us on social media? And if they start thinking that, is that going to affect them and actually push them more towards not guilty, maybe? But the point is, it shouldn't have come in my opinion. It just shouldn't have come in. And it seemed like at first the defense didn't want it in. Then the defense, when it was in, they had to try to deal with it. And the way they dealt with it was like, well, you're getting pressured because you lied or whatever they said, but they made up, reasons for people getting frustrated with them, that it wasn't intimidation out of left field, but there was reasons for it. And then it just becomes a whole mess and a sideshow to the trial. But the jurors are listening and it affects the jurors. And it really didn't prove or disprove whether Karen Read committed this crime, which is why I just don't think it should have come in. Then we get to paragraph 10. During jury deliberations, we could hear protesters outside screaming and yelling. So paragraphs 9 and 10, okay? Paragraphs 9 and 10 are situations where the next trial could be affected. Number one, will the witness intimidation discussion come up in the next trial? I hope it doesn't, because it does have an effect on the jury. They do start to worry. That's prejudicial, and there's almost no probative value, in my opinion. Number two, where are they going to allow protesters or supporters or anybody to stand? What are they going to allow them to do? Because yes, they have First Amendment rights, but they absolutely do not have a right to pressure a jury. Now, she didn't say which side the protesters were screaming for or that they felt pressured from one side or the other, just that they obviously knew they were there. They knew they were there. They heard them. They felt their presence. During our jury service, the members of the jury would meet at what was supposed to be a secret location to be transported to and from the courthouse by bus. After being discharged from the jury service on July 1st, 2024, we were taken by bus back to what was supposed to have been a secret location where we observed what appeared to be members of the media, including photographers. I was so much in fear on my way home that I pulled over to the side of the road to see if I was being followed. Thankfully, I was not being followed, but that was and remains my mindset. If juror names are made public, we would be constantly threatened and harassed, and there will likely be a physical confrontation at some point. I mean, that seems very, very confident that that's what's going to happen, and that's horrible. This is the worst. This is not how it should be. This is not how jurors should feel. And this is how I always talk about, when we talk about stuff, we should be able to disagree. I don't want to make anybody feel on this channel that if you disagree with me, that we can't have an open conversation about it. I would like for that to go both ways, right? For you to be okay if I disagree with you. But they should not be feeling like this, that they're going to be harassed and threatened and physically harmed because they disagree with the outcome of a trial. I mean, they really shouldn't. And it is very unusual for jurors to say stuff like this. Even in very high profile cases, when jurors have had to make tough decisions, jurors shouldn't feel this way. And I'll just tell you right now, judges and the legal system, they do not take this lightly. I see a lot of the comments saying, this is BS, think the juror's soft or whatever it may be. Now, listen, is there a way that, the one side or the other, or somebody could have gotten to this juror? We talked about that as well. Will either side be able to influence a juror? Will the media be able to influence a juror? Of course, that's possible. We just have no evidence of that at this point. And I will just tell you, this is not something that's going to be just kind of thrown away and disregarded. It's really not, legally speaking. This is enough to basically get A lot of things changed if you have a juror that says this. Afton, if defense gets a verdict for 2 counts on the record, doesn't that mean names become public? Will that influence jurors on what to say? So will it influence jurors? I don't know the answer to that, right? I don't know what's going to influence them or not. I think it could. And their names will probably eventually become public because that is the standard. It's the exception to keep their names hidden. Can you look into Ashley Benfield trial? Starts July 22nd, 3 weeks. It's a Florida murder trial. Shot her husband. She claims self-defense. Thank you. I will take a look at it. People have been sending me kind of overviews of the case. So I will have to take a look into that. And if enough people, right now, I'm getting kind of sporadic requests for it. If enough people want it, I will jump into it. What can you say about your fantasy league large field tournament when? We will be doing it. I think we usually do it in August. I think we did 14 teams last year. We'll see. We'll see. Do the jurors have to pay for the lawyers if needed, or is this financial support for such things? They have to pay for the lawyer on their own. So yeah, it's tough. So that's why I'm saying that's not what we want. That's not how we want it to go. Amy Z said, what has Turtle Boy done that's illegal? I have no idea. I haven't looked into it. I'm not going to look into it for the most part. I'm going to try to stay as focused on this trial as I can. And not get into all of the other external things that are going on. So I don't know what he's done that's illegal. Asking questions isn't violence. I agree with this 100%. I don't think asking questions is violence at all. I don't think it's a crime to ask questions. I don't think it's a crime to film yourself while you're asking questions. Maybe it's annoying. Maybe people think it's annoying. I know we've all seen those videos of cops where the kids think they're so smart and they're like, you can't do this to me. I know my rights. And they film themselves while they do it. I get it. But asking questions is not violence. I agree with you. But they're not saying they're afraid of people asking questions. Right? Peter, I'm starting to see a pattern. There's at least one bad comment when you post about Karen Reed on X, and usually from the same people. Haters going to hate, right? I mean, it's more than one. I'll just say it's more than one. But it's on both sides. Honestly, both sides have had issues with my takes throughout this entire case, and I assume they're going to continue to have issues with my takes. I don't expect anybody to really be fully, yes, I agree with everything he says, because I don't feel like I'm far down the line enough into what anybody else believes to really focus on that. And that's not what I'm here for, right? I'm not here reporting things and breaking news. I'm frankly just looking at it, trying to explain how a lawyer, how a judge may look at this, may use this in an argument, may use this in a future motion, or argue it in a hearing. That's really the point of what I'm trying to do here. Mary Claire, Mick Alberts claimed Turtle Boy was intimidating them when they were witnesses. Peter, what do you feel Bev could have done to manage all this better? I don't think it should have become part of the trial. I really don't think it should have become part of the trial, number one. Number two, I don't know what the intimidation charges are. I don't know if there's accusations of physical harm or if it really is just intimidation with words and with presence and things like that. I know he had to be sent out of the courtroom when certain witnesses testified. And then, I don't know what the accusations are, but what I will say is if there's no accusations of physical violence, that would make it even weirder that now she's worried about physical violence, number one. I mean, I know there's been accusations of physical violence from the Turtle Boy to the Alberts or the McCabe's, like he has accused them of that. So maybe she's talking about that. I don't really know. But the point is there's a lot of stuff going on the sidelines that could negatively affect this case and negatively affect the opportunity to get this case to final resolution. And that is a worry. And that's something nobody should want. Sarah, publicly exposing people has become very real and serious problem in this society. And this motion proves how much fear of that impacts people. I agree. And it also proves how important criminal charges are and how people use criminal charges, right? When you get charged with something criminal, and that's what we're talking about with like the Lank guy in this trial where he was like, yeah, I charged the guy that I punched with a crime and I didn't let him file a police report. Do you know how powerful that is? Because you can use that now forever that guy's been charged with a crime. And a lot of those end up in convictions or plea deals. The power to be able to charge crimes is very different. And that's why the power the government has to be checked. It has to be kept in check. Or else I promise you it will affect you or someone you love one day. And you will want it to be done fairly. Jojo, don't forget to hit that like button. Thank you, Jojo. All right, let's get to the next page here. I'll answer more questions after I read this page. Since being discharged from jury service on July 1st, I have read multiple news articles about the case and the attention that this case has garnered across Massachusetts, New England, and the country. I agree. There are clearly people who have very strong opinions about the case and about the jurors who deliberated over many days. I have seen articles, comments to articles, and postings about the verdict saying some very nasty and dangerous things. I agree. I have too. And that's why people that think that they're helping, when they go too far, it can really start to hurt. And I know people on both sides think they're fighting the good fight. And it's important to fight the good fight. It's important to expose wrongdoing and fight for truth and seek justice. That's really important. But the law of diminishing returns can apply to you if you do it in a way that creates as many problems as you may be solving. And I think we all need to think about that. And myself included, I need to think about that as when I talk about these things. That I need to make sure I'm not creating more problems, trying to solve the problems of discussing the legal and judicial process and what I think should happen or shouldn't happen or what's right and what's wrong and how we look at this stuff. I need to make sure I'm not creating more problems than I'm solving with my comments. Some individuals have expressed outrage and anger that the jury did not acquit the defendant. So very clear what side this juror is talking about being problematic. Some individuals have expressed outrage and anger that the jury did not find the defendant guilty. And then she says, without any qualms, the other side. I keep saying she. I don't know why. This juror says they have seen it from one side. Okay, good. We're getting one side. And from the other side. So this is not just about one person. This is not just about one side. I truly believe that. And I truly believe that just not one side is to blame. I think there are people on both sides going too hard and having more of a negative effect on something that I think they truly do want to have a positive effect on. And I can respect that. Publicly trying to have a positive effect on things. And I encourage it, but we need to be careful how we do it. RJ, hey, Peter, do you think people waiting for the juror bus is evidence/proof of a leak in the court? No, because it could also be a leak with the attorneys. There's just so many people connected to a case. We found that out with Becky, Miss Becky. Just don't know. Joe, are you going to do another pickleball video? Yes. I'm making an executive decision right now and saying yes. I don't know when, but eventually. We got some things coming actually with that. That'll be cool. John O'Rourke, planning anything fun for the chat for the Olympics? Since you have viewers from all around the world thinking outside the box. Ooh, it could be fun. Yeah, I like it. You just gave us our idea, John. I don't know when our next Members Only Live is, but we're going to put this on the list. Christy, thank you for your neutrality. It helps to know we can trust your coverage of trials. Well, a lot of people don't like it on both sides, right? And a lot of people will say this is proof of X, Y, or Z or this or that. But is this how I've tried to be throughout the entire case? That doesn't mean I'm not going to come down on one side at the end of a case after listening to all the evidence and testimony, right? That's just not how it's going to end for me. But I do my best. So I thank you, Christy, for that. Tina, thank you for gifting 5 memberships. Just yesterday, back to the affidavit, I read an article in the Boston Globe with the headline, Karen Reed case ended in a mistrial, but the diehards haven't given up. In approximately the 12th paragraph of this article, an administrator of a Karen Reed-focused Facebook group was quoted saying, the people who were on the fringe of being interested in it are now engulfed. The anger level was at a 9 before, and now it's at an 11.5. The article characterized this increase as a rising rage. And our country is kind of, going in a direction where we have multiple things to point to that could be potentially problematic or pointed to as creating something that's going to eventually become physical, that these increased issues like that, and people are going to run with it anytime they can. People are going to use it on both sides. And it becomes an issue that if you think this juror has ulterior motives, it's going to be hard to prove, which is why we don't want to give people the excuse to even say or do or feel things like this. And we could control as much as we can control, which of course is not everything, but this is tough. Later in this July 15th Boston Globe article, another individual interviewed by the reporter said, people are insane about this case. If they don't agree with you, they'll try to dox you. I understand the term dox to mean that individuals will publicize someone's personal information, including someone's residential address, occupation, business address, etc., publicizing any personal information in this context, exposing me or my family to unwanted and likely surprise encounters with strangers who likely have an axe to grind with any juror. I mean, for those of you guys that are calling BS on this affidavit, do you think this juror is wrong? Let me know in the chat. I'm going to scan the chat here as I read the next paragraph. But do you think this juror is wrong? There's a new defense motion, juror E. Yeah, hold on. John happens to be in the office today. So Mara said, new defense motion, juror E. Tag me on Twitter. Tag me on Twitter or send it to my DMs on Twitter, and I'll try to get right into it as soon as we're done with this affidavit. Okay. Izzy beat us to it. Send over on X. Sorry, excuse me, not Twitter. On X. Thank you for all you do. Thank you for all you do, Izzy. Okay. Yeah, I'll be able to get it. I'm on Twitter right here, so I'll grab it in a second. All right, later. Don't agree with you. I have seen social media posts that were very demeaning of and attacking of the integrity of the trial judge. If someone's going to attack a sitting trial judge, I see no reason why they would not demean and attack verbally and physically. They keep throwing physically in here, which I think is very interesting. A juror that sat on this jury. And again, I think it's okay to disagree with the judge, but again, public threats and certain things with the judge, this juror is not wrong. Why would they not do the same or worse to a juror? I understand there are individuals who are upset that an impoundment order was entered and that they are actively seeking the identity of the jurors. For example, my attorneys have made me aware of a video posted by a blogger / journalist. And again, you guys would know more than I if this is Turtle Boy or somebody else. I have no idea. British said the Switzerland of law tube. I don't know about that. But we'll see. We'll see. For example, my attorneys have made me aware of a video post by a blogger journalist whom I understand to be a person who has been charged with intimidation. That maybe gives us an indication if that's Turtle Boy. Related to this case, speaking about the trial and the jury's inability to reach unanimous verdict on all counts after trial. In the video, the blogger initially states that he has identified the jury foreperson in the case. Not only does the blogger state that he has identified the jury foreperson, but also where this person lives and what the person does for a living. A link to his video can be found here. I would be thinking that anybody in the courtroom at least has more of an idea of who these jurors are than anybody else, right? Wouldn't you think? Because they did see who they are. They know ages, genders, things like that. And if they wanted to do something, they probably at least could have tried to do something at this point, and maybe they have. I don't know the answer. In the same video, the blogger demands to know the identity of the expletive idiot on this jury who did not vote his preferred manner and further that trial. So they posted the actual link. So I assume if I clicked it, I could see who it was. I assume we think we know who it was. Whoever did that subverted justice. Like they helped cover up for a murder. As far as I'm concerned, F them. That's what I think. So here's a quote, since we have a quote right here, that I can vehemently disagree with. I absolutely do not think just because a juror voted guilty or not guilty or whatever their vote was, that they were involved or colluded with either side. Because these accusations could be thrown both ways. Oh, they're in the cover up, or oh, they colluded or paid off by the Karen Reed defense team. I don't believe that until we have further evidence of it. At this point, I do believe the jurors were trying to do their duty, come up with the best answer they could, and vote their conscience and what they felt the truth was. I do believe that. Who outed the Chesna juror? Remember that? The woman who hung the Michael Chesna trial in July. The jury lists are public, so I got the jury list and I went down to the list and I found the juror who hung the jury and I shamed her, as I should, because it's shameful. Again, not great. Like these are the types of things that if you say it's not legitimate that the juror is going to be harassed and they have evidence of other jurors being harassed in similar situations, that is going to create future action taken by the court, taken by the Commonwealth. Because regardless of what anybody thinks, justice or being fair is, there are certain things that do cross the line. There are certain things that do cross the line that we have to be careful to protect and not allow. And what this can do is it's not going to affect the Michael Chesna trial, right? It's not going to affect Karen Reed's first trial, but it could affect future trials. Making certain threats and making good on them, right? A lot of criminal acts, it has to be a reasonable threat. If I say I'm going to, here's a good one. Cargo asked me thoughts on Tim Tebow as a FSU grad. If I said I'm going to slap Tim Tebow, that's not a reasonable threat. I wouldn't slap him. If I did, he would probably welcome that and handle me very easily. But number two, I don't know where he is. I'm not going to get close enough ever to slap him anyway, so it's not a reasonable threat, right? And I haven't slapped another man in my entire life. So not a reasonable threat, not making good on that threat. What do I think of him? I think he seems like a very great dude. If he seems like a very genuine dude, I wish we could have pounded him in the dirt many, many times, and it just didn't go our way, unfortunately. That's my thought about Tim Tebow. All right, next paragraph. A link to the post can be found here. I understand that the above mentioned blogger has been accused of harassing witnesses in this case, like the fifth time they've said that, including by organizing crowds of people to harass from outside their homes. And I'm aware that he has made public statements from a blog in 2003 to the effects of, okay, hold on, we're going to go to the next page here. Murderers and those who cover for them do not deserve to live a comfortable life while Karen Read suffers and fights for justice for John O'Keefe. And again, there's a difference between words and actions. There's a difference between questions and violence. And when you have this many words and these kinds of words, sometimes judges, sometimes law enforcement, sometimes prosecutors have to make calls of where are the lines and where do they get crossed. Are they always right? No. Are charges the same thing as convictions? No. But it's not nothing, right? It's not like coming out of left field. A lot of people breaking that juror E has come forward. We will look at that as soon as we get done with this affidavit. But we've also seen, on the other side, while we've seen bad words coming here, or negative words and sentiment or threatening type words coming here, we've also seen police reports that have had misstatements in them or typos or things that have been problematic on the other side. So I think that's the point of just keeping an open mind with the justice system and wait until we actually have a resolution finality before convicting somebody in the court of public opinion. And I would say that about anybody charged with a crime. Cats, Juror 1, Paul in Maya Kowalski trial was dragged through the mud. There was a whole Reddit thread developed to digging up dirt on him. It's a real thing in today's world. Doxing, harassment, cancel. I agree. Have you heard of the Samantha Wall murder trial in Michigan? I have not. Kevin, can't we all just get along? Mob justice not good. I agree, Kevin. Even if we disagree, can't we just get along? Right? Especially us. We on the outside watching this, following this. Boston Breezy. Pita, will this affect Karen Read's motion to investigate the verdict? Unfortunately, I think it's opening the door to stating that this could create potentially more problems. I appreciate Turtle Boy and all he's done to bring attention to this case, but he did cross the line, in my opinion, with going to the kids' games. I don't even know what you mean by going to the kids' games. The kids of people, the O'Keefe kids? Again, I don't know everything that's happened in the background. I don't want to, jump to conclusions or pass judgment on it, but I will say it. I've said it a million times, that handling yourself appropriately and professionally and kindly to people even you disagree with or even that you hate is what I would promote. That's what I would promote. Can Bev use this as an excuse not to question jurors on their votes? I think she might try, but in my opinion, it would be done sealed. We wouldn't know their names. We wouldn't know their ages. We wouldn't know their genders, things like that. In a similar fashion that we've seen another case done. It could be done in chambers without even the public viewing it. It could be done distorting their face, distorting their voice. There's a million different ways to do it where you wouldn't have to out them. So I think not questioning them would be an extreme measure and reaction to this, personally. Amy's positive pathways. I keep saying she too, but she is talking about both sides. I feel like stuff the lawyer showed her biased stuff. Well, potentially. And maybe this juror really does want to block their name. So the lawyer's like, here, use this, use this, use this. And that's good lawyering and good arguing because all of this stuff is out there and can appropriately be used to keep their name sealed. So if that's the end goal, the lawyer did their job. Dana, Peter, I'm surprised that jurors' names are published. You mean like just generally? I disagree with that practice. They shouldn't ever be made public. Why are jurors' names made public? Well, we also don't want rogue jurors. We don't want jurors to go in there and commit some crime. We don't want jurors to go in there with some agenda and nobody ever knowing that they have that agenda, right? Like just imagine if, I almost went with a political analogy just to make it really obvious, but I decided not to. Imagine if you knew somebody that hated somebody, but they were on a juror and they said, oh, I don't know this person. And then they convict them of a crime, right? And then you can come out and be like, whoa, they were on that juror. I found out. I saw their name publicized. It's all about accountability. It's all about keeping things accountable, keeping things public. The community has a right to know who in their community sits in judgment. Everybody should do their civic duty. And this could literally be any one of you. So why would we want to threaten each other and punish each other and hurt each other for doing our civic duty sitting on a jury? All right, let me keep reading here. If, as he stated, this blogger believes the members of the jury, which I served, help cover up for a murder, and he further believes that those who cover up for murders are legitimate targets of harassment, I fully expect that members of the jury will be subjected to efforts to harass and shame them, with a very real possibility that some physical confrontation will inevitably occur. My concerns are not limited to a particular blogger or a particular side of this case, and I would agree with that. I am aware that there are other outspoken bloggers, commentators, and groups of people who wished for a guilty verdict on some or all charges against the defendant. I am aware that there have been physical confrontations between two sides of supporters, which is why it's like, if you're in on this and you're really in, try to avoid this stuff. Try to avoid being something that somebody else could throw out to maybe either slow down the wheels of justice or stop it altogether. An example of this is from two recent postings by an individual who appears to be a reporter from New Bedford. In today's post, she stated that she was in court today defending against harassment charge against her and her pursuit of a counter harassment charge. Yesterday, this reporter posted about getting protection from another blogger. While I do not know the facts concerning the court appearances, it is very evident that individuals on all sides of this case have acted irrationally and aggressively over the past few years, which has caused multiple court appearances by parties seeking protection of the courts from other individuals. In light of this mistrial, there is no end in sight to this irrational behavior, which clearly continues today. Jurors will undoubtedly be subjected to harassment and likely physical confrontations if their names are made public. So it sounds like they might even try to block it forever, which I don't think is necessarily going to work. And I will just tell you, not in this video or any other, am I trying to go and get with people on either side of this case. Doesn't mean I hate anybody on either side of this case. There are definitely some people who's been in the comments that I dislike and would rather not interact with. But I am not going to try. You can't try to pander to one side or the other. You really can't. Because the first time you say one thing that they don't agree with, they will crucify you just like the people that they hate. And it has happened. And so you just have to be careful. You have to think for yourself. And if you think she's guilty and you feel like you have real reasons for that, focus on that. Focus on the reasons you think she's guilty. The evidentiary reasons that came out at trial. If you think she's not guilty, same thing. If you think she's not guilty based on the evidence or lack thereof that came out of trial, focus on that and discuss that. Personal attacks on people, doxing, chasing, harassing people is not going to get you the result you want and is not going to get you a just result either, in my opinion. I sat on a quad redrum. Okay. Jury. Nice. Nicely done. The defendants, 4 families, were constantly trying to intimidate us. The court did nothing to protect us, and we walked to the jury parking lot alone every evening. Juries shouldn't be afraid. I agree. And yeah, this is not the only case something like this has happened. Can this be used against Turtle Boy in his case? I don't think so, because this person's not a victim in his case. I don't find this relevant to his case at all. Paragraphs 9 and 20 are contradictory. All right, let's go back and see 9 and 29. I also recall testimony of at least one witness being harassed. I feel my family and I will be harassed. Personal safety compromise. Okay, then let's see 20. I understand the above mentioned blogger has been accused of harassing, including organizing crowds of people. I think they're talking about 2 different instances. The issue with the links, they are from the Commonwealth side and are only chosen clips rather than straight from the blogger's video. Very selective and suspect, but they do mention both sides, which they're right about. It is both sides happening. It's not just one side. And I hear a lot of people saying it's just one side. It's not just one side. Casey Cat, Turtle Boy never threatened physical violence. Mick Alberts, Jen in particular, said she felt intimidated. He's the one who broke this whole story. They are big mad. And I can understand that. And I can understand him feeling like this is all retaliation and coming after him for exposing the truth. And he should absolutely not be convicted if that's all it is. Right? But if lines were crossed and criminal action was taken, then he probably knows that there's going to be a response for that. Can you cover the Tyler Daisy trial? I'll have to look at it. And if you guys are interested, you know what to do. Let me know in the comments. Peter, you need to work on your Boston accent. I don't do accents well. So many jurors coming forward and still none denying the unanimous on 1 and 3 wild. So yeah, that's where I'm getting here. In light of the mistrial, there's no end in sight. Let me see. All right, here's the last paragraph. So let me finish with this. And then this is one of the points I was going to make, Christy. We read a lot and saw a lot. in this affidavit. But what did we not see? This juror, I will tell you, I am confident. I can't know this, but I am confident with context clues that this juror has read and kept up with and followed the motions to dismiss and the other affidavits of the other jurors. They know just way too much and have already said they've been following this, that if that was not true, I don't know why that wouldn't be in this affidavit. My affidavit in motion should not be interpreted as an indication of how I or any other jurors voted on this case. They emphatically don't even want to talk about the vote or how I or any other juror feel about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large portion of the public who intensely followed this case. I agree. I wish to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during our deliberation. It was an honor to serve on the jury. It was also a significant sacrifice of time, which I understand and anticipated when I was selected. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. If jury names are made public, I will be subject to nonstop requests from comment about jury deliberations. I would prefer to not have to respond to these inquiries. However, what I fear is not only that I will be subject to requests for interviews, but that I will be targeted and harassed because of what I did or did not do on the jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I am not prepared or equipped to anticipate and prepare for any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family. Again, something we absolutely do not want. Anti-Corrupt said, I feel that Bev failed to speak to the jurors and wasn't concerned about their safety then. This is an excuse. I don't know. I'm going to answer a couple questions here, and then we're going to, at the same time, I'm going to try to look and see if I have this. I don't think I can zoom in on it. It's kind of hard for me to read. Okay, no, it's pretty short. Yeah, I can read that. This juror is citing anti-Karen Twitter pages in this filing. We shouldn't go around condemning people who have done nothing wrong, like Turtle Boy and Free Karen Reed. Hi, Peter. Happy anniversary. Thank you. Belinda, if this juror is so scared, why were they not intimidated by the terrifying stare down from Brian Albert and co. during closing arguments? That was awful and should not have been allowed by the judge. So what I'll say is, if you feel like you're being harassed or intimidated, it's usually by people you disagree with. So the one that said they felt intimidated by, some of the people being there at closing arguments probably disagreed with those people that were there at closing arguments. This juror probably disagrees with, the bloggers and reporters and people that she thinks disagree with, or that they think disagree with what they voted on. So I don't think it's unusual for jurors to feel the intimidation from people they disagree with. Are there laws against jury harassment? Yes. After they have been dismissed? Yes. If it's demonstrated they have docs info and make threats, can they be charged? Yes, they can and should. Salvatore said, Turtle Boy can be obnoxious, but he gets the job done. And listen, people don't have to like people's personalities, right? That's not a crime to, be obnoxious. There are lines that are crossed that become criminal, but if you don't cross those lines, it's not criminal. Doesn't mean you always have to like somebody's personality, or even if you dislike somebody, if you disagree with them, if you agree with them. That's why we have laws, right? So that they're clearly defined and only criminal action can be criminalized. Marcia, Peter, what about Albert's coming to court and one of the jurors stating it was intimidating? Again, I think that's absolutely potential evidence of intimidation if the jurors felt intimidated there, even if it wasn't done on purpose. And a lot of this might not be done on purpose, but it still could affect the jury now and in the future. What's the definition, statute of invoking or stalking? It's different in every jurisdiction. I don't know what it is specifically in Massachusetts. Usually it has to be repeated. Usually those threats have to be reasonable and legitimate. Again, like we talked about before. Should they do a change of venue for this? I kind of think they should. What do you guys think? I kind of think they should. Bev impounded the names and definitely tagged you on X. Yes, we read that in the beginning of the video. Another juror came forward. See Ted Daniel on X. Ted Daniel's another one where I've seen a lot of the documents on. Just shout to him. Tyler, Daisy is a crazy one. Richcraft murder, etc. The trial is on day 2. So I usually really try not to start trials that have already started. Sam, I was in Judge Canoni's jury pool the original day they were supposed to do selection in this case. I don't envy those that got picked. I get it. I don't either. I choose to do this and I don't really envy the crap I get. for it, right? And I choose to get up and do this every day. It's annoying and it does not have any positive effect on me at all from either side, just FYI. So I don't think that it's going to have the type of effect people may want it to have on jurors now or in the future. Anna, Peter, bruh, appreciate the non-biased coverage. When you disagreed with your dad, when you stated in the name of justice, the prosecution should want to know the truth. We knew you were a real one. Love your show, Tim and Anna. Yeah, and that's the other thing is like, people get on us sometimes, me and my dad, if we argue or disagree on things in our videos. It's like, that's life. And it's okay. If you can't get along with people you disagree with, life's going to be hard. Infinitely harder than it should be. I can have very good friends and family members I disagree with on things. That's got to be okay. It's got to be. Salvatore, Peter, how do you think this is going to turn out Monday? Oh boy. Like I can predict, Salvatore, come on. I think they're going to pick a trial date, number one. What I hope happens is the judge either makes a decision to allow the juror interviews or sets a hearing date saying, we're going to come in, we're going to clear 30 minutes or an hour or 2 hours or whatever it takes for you guys to argue this, then I'm going to make a decision. I hope it's not an infinite delay. Pierre, I feel like while some things may have come close to the line, it comes from both sides. The Commonwealth has weaponized the law. Turtle Boy has been outspoken but not violent. Azam, off topic, talk about accents. I really want to hear you do a British accent, Peter, on the members only, maybe. The only way I can even try to do an accent is if I listen to it immediately before trying it myself. Okay. I have this up. Let's get to the newest affidavit. Yeah, it's impossible for you to read. Don't worry. I am here to read for you. I, Alan Jackson, declare I'm a partner at the Los Angeles law firm of Worksman, Jackson, and Quinn. I've been licensed practice law since 94. I'm counsel for Karen Reed, appearing on behalf of the Commonwealth. On her behalf in the Commonwealth, sorry. On Wednesday, July 17th, I was contacted by Juror E. That was literally yesterday. True name and identity withheld to maintain anonymity. Based on my conversation with Juror E., and the juror's physical description of himself, herself, where the juror was seated, and the juror's name and occupation, which was also disclosed during the voir dire process, I was able to positively identify Juror E as a seated, deliberating juror in the trial of this matter. Juror E stated that he/she decided to contact me to provide information about the results of the jury's decision-making following deliberations. Juror E explained the jury was unanimous on 1 and 3 that Karen Reed was not guilty of those charges. Juror E went on to state that the only count in which the jury was deadlocked was in relation to the lower charges on count 2. So again, he's even saying they didn't do the superior charge on count 2. They were really arguing about the lesser included. I took that to mean the lesser included offense, associated with count 2. In case you didn't realize, I haven't read this yet. Juror E indicated that he or she was happy to provide such information, but wished to remain publicly anonymous. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States of the state of California and Commonwealth of Massachusetts, executed this date, July 18th, 2024 at Los Angeles, California. So what does this mean? Why is this one maybe even more important? Because I believe A, B, C, D, E, this is the 5th juror to come forward and confirm not guilty on counts 1 and 3. And what did we hear from one of the other jurors that the guilty vote was on count 2? Maybe it was lesser included, maybe not. But we heard in an affidavit that it was 8-4. So what that would mean is likely one of the jurors that voted guilty on count 2 has spoken to the defense team and confirmed the not guilty verdicts on counts 1 and 3. That's important to me. And so now, even if we just have these 5 jurors that want to come talk to the court in some kind of juror interview, at least one of them is going to say, yeah, I was a guilty vote on count 2. Maybe they won't even talk about count 2. Maybe it'll just be counts 1 and 3. But this adds a lot of credibility, in my opinion, that it's not just the people that were fully not guilty that are coming forward and talking to the defense attorneys. And it makes me wonder, is anybody reaching out and saying these things to the Commonwealth and we're just not hearing about it? It absolutely makes me wonder that. not going to throw out any accusations, but it certainly makes me wonder that. Benfield, check out Grizzly True Crime Summaries. Okay, I'll have to do that. Elizabeth, miss the days where you could disagree and be friends. Yeah. I mean, that's still how a lot of my friends are. But I agree with you. And that's how a lot of people in the chat are, which I got to say. It's 11,000 of us in here now, and a lot of us are very cool disagreeing. And I appreciate that. And that's what makes it so great, right? You can say whatever you want about the videos and the analysis and whatever, but like when the chat gets annoying, it's annoying for everybody. And this chat is very rarely annoying. Like this chat is the best chat on YouTube with the ability to think clearly and discuss stuff, even if we disagree. And that's something we need to keep doing and keep going forward on. And if we can do it in this case, I kind of think we can do it in any case. A sixth juror has come forward. All right, tag me on Twitter if this is true, unless you're talking about Juror Doe being Juror 5 and this juror being Juror 6. But if Juror 6 is happening, we'll try to check it out. Romy, Turtle Boy did an investigative report on my brother-in-law a few years back. I don't always like his style, but he wasn't wrong. Yeah, I mean, I get it. Hi, Peter. Who has been charged with witness intimidation? Turtle Boy has. Charged, but not convicted. Amy's Positive Pathways. From Massachusetts. Never want to be a juror again here. Also, it's all over Massachusetts. Everywhere I go, people talking about this case. What venue? I agree with you. And that's hard. That's tough because when we talk about where we could possibly change the venue to, that's where it becomes a problem. That's really where it becomes a problem. Are you finding anything on 6? Another person said it too. All right, yeah, tag us on X or message it to us on X. Let me pull this down and do a quick search for it. 6 would equal F. Yeah, that's what I would assume. 6 would be F. Let me see if anybody I follow has it. We can look up Ted. What's his name? Ted. What is the guy's name that's doing all of it? Ted Daniel. There it is. All right, let me see if he's got it up. So there is this filing that we haven't read yet. So let me pull this up for us to read real quick while everybody's still looking for juror number 6. Now comes the defendant, Karen Reed, by and through undersigned counsel, hereby respectfully submits this second supplement as reflected in the attached affidavit, which is the one we just read. Juror E has confirmed that the jury was unanimous on counts 1 and 3, that Karen Reed was not guilty of these charges based on the attached affidavit and all of the reasons set forth in its opening motion, the first supplemental memorandum and reply. The defense respectfully renews its contention that the jury acquitted Ms. Reed on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial as to those counts, and therefore the double jeopardy protection of the federal and state constitutions require that those counts not be retried. If the court would prefer to rule on the basis of affidavits executed directly by the jurors, the defense respectfully requests permission to initiate contact with jurors A, D, and E for the sole purpose of asking them to affirm the accuracy of the 3 affidavits of Alan Jackson. So now what he's doing here is he's saying, if the court wants to just throw out the, hearsay ones, the ones with the intermediaries and the informants, if you don't feel like those are strong enough, now we're up to 3, Judge, who are coming directly from jurors. 5 total. That's almost half the jury. How are we not going to dig further into this? We have to dig further into this. I just don't understand why we would not want to know the truth of what happened. I don't understand that. Peter, a verdict form should always be filled out, even when it's deadlocked, or the judge should ask if they're hung on all charges. Why isn't this done? We usually don't want to give the jury the option or let them know that they can get deadlocked. Obviously, they know that, but if we put like a deadlocked box, I think it would get checked a lot more than it does currently. We do our best to give jurors everything they need and to make a decision, but at the end of the day, we need them to make a decision. We talk about in every case how hard it is to get 6 or 12 people or anywhere in between to agree unanimously on something. Dr. Bob, I don't drink, but oh man, I may need a stronger coffee after this. I agree with you. I'm halfway through mine already, and it's only 4:30. A change of venue is imperative for a fair trial. We got to find a fair venue, right? Now you agree that we are the best chat, Peter. Yay. The best. Peter, Runkle, and EDB have the best, friendliest, safest chats, in my opinion. Agree to disagree and move on in life. Hopefully we all have a long life. I agree. Because guess what, Lori? We may agree on the next one. Or not. If we agree on this one, maybe we'll disagree on the next one. And that's kind of what makes it cool. It's like, oh, we were on the same page on this case, but not on this case. Why? Right? Because we may see things differently. What about our experiences can bring something different? And that's what I love about these discussions. Do you see this impacting who gets in court in the future? I don't know what you mean by that. Like, journalists or whatever. No, all that stuff's already in place, right? And people were removed for intimidation stuff. I think it's still going to be handled the way that we have it currently set up. Jennifer D, I saw the Alberts making threats. I don't blame the jurors for feeling scared. I know it's the trolls that hate Turtle Boy wrong the motion of the one being scared. Kate Peters works with the DA to take Turtle Boy down. These jurors want this documented before Monday. I probably would too. Well, if they want it to have an effect, the more that come forward, the better. Lisa, it's looking like all the jurors are going to come forward about the not guilty verdict. I mean, I don't know. We've only had 5, and Monday is only a couple days away. There's no way they can't look at this further. It's going to be disturbing if it's not settled. I agree. I will have almost no choice but to be like, wow, this really sucks. And there's a cloud overhanging this now for the rest of this case if we don't at least get to talk to jurors. But remember, everybody, clamoring for it. If one of the jurors said, no, I was going to vote guilty, it's all over. And retrial is totally appropriate legally. Anti-corrupt. Now, I personally don't think there's enough evidence for it. Okay. I don't have to qualify everything I say, but I think jurors would have been harassed regardless of what Bev said, and they shouldn't be in fear, but Bev influenced their decision, in my opinion. Mary Claire said, could this be precedent-setting case? Agreed. It's the best chat on YouTube. Thanks to you. You lead with integrity, and it's appreciated. I think it's hard to lead 12,000 people, right? So I think a lot of this is a testament to you guys, but I appreciate that. I think there's going to be some precedent set by this case, but I don't think it's a lot of this is not like novel legal arguments. Like the Crumbly case to me was a lot more of a precedent-setting type of case. The Scott Peterson case in Florida for the resource officer, that was a more precedent-setting case that, if that would have gone the wrong way, could have opened up certain floodgates to things. But this case, I think, is going to be one that's studied and talked about. I'm not necessarily sure it's going to set precedent. I would say not really. And thank you, Melissa, for this super sticker here. All right. So I don't see anybody now saying that there was a 6th juror. Okay, so everybody was maybe a little bit confused between 5th and 6th. That's no problem. Okay. Turtle Boy said a 6th juror has now been confirmed, I guess. So I don't know. Okay, so we'll see. We'll see if it comes out and anybody sends it to me. It wouldn't surprise me, right? If a 6th juror came out at this point. We've already had 5. Rue said, someone strung up a poor turtle at Turtle Boy's parents' home. Reminded me of Godfather, Horse's head in bed. Jurors are justified to fear intimidation and harassment. I agree with you. I do agree with you. And welcome to Els and all the new members. Okay. Oh, somebody said it was a typo by Turtle Boy. Okay, I don't know. We'll see if there is. We'll see if there's a 6th juror. And if there is, we will for sure be talking about it at some point. We are right at an hour, which used to be always what we did, and we're back doing that. So hit the like button for keeping it under an hour. Make sure you guys subscribe. If you haven't subscribed already, hit that subscribe button. Unfortunately, it doesn't seem like this case is ending anytime soon, so hit the reminder bell. And every time we post a video about this case, you should be alerted if you hit that bell. Do you think more are coming forward now that their names have been impounded indefinitely? I hope so. I hope they all come forward. I want to know what they said. I want to know the truth, right? And I think that the truth will help this process move forward the way that it should in truth and justice, of course. All right. People are asking, who is EDB? Emily D. Baker. Runkle is Runkle of the Bailey. Those are the other 2 YouTube channels somebody mentioned, and another one that has good chats. And I think Rob from Lawn Lumber was another one. All right. Last one. Belinda, any chance the Commonwealth drops all charges if the FBI indict Albert, McCabe, or even Higgins. Is there any chance? Yes. I don't necessarily think it's all that likely. That's my guess on it. Okay. That's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.